I welcome you all to lecture number 10, Sale of Goods Act 1930. This is a part of CA Foundation lecture series sponsored by Sri Jayendra Rank Zone. I'm your mentor, Shekhar Gehlot. So now, in this lecture, in continuation of other lectures, we are dealing with the rules regarding sale and delivery. Okay, rules regarding sale and delivery. We have discussed 13 rules till now. Let us now discuss the 14th one. You all are requested to give it a quick look, and then we will analyze the section. Rule related to acceptance of delivery of goods. Now we are discussing about acceptance of delivery of goods. Okay, now this rule talks about how delivery is made. Okay, but would it mean now merely when making a delivery the delivery is accepted? Okay, now what I say is that suppose I place an order with the seller that I want 100 quantities of jute. Now he has placed the 100 quantities of jute at my office in my absence and has left. Now, would that automatically mean that I have accepted the delivery? Merely because he has made the delivery, does that mean that I have accepted the buyer has accepted the delivery as well? No. Okay. Now, let us read the section further. The buyer is deemed to have accepted the goods when he intimates to the seller. When he intimates. Okay. That means the intimation is required, that he must intimate to the seller that I have accepted the goods, or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller. Okay, now this is the other part. Or when, after the lapse of a reasonable time, he retains the goods without intimating to the seller that he has rejected them. Okay, so now this is the way in which a delivery of the goods is accepted. Now, analyze this section. Now, acceptance is understood to have taken place. Okay, acceptance of delivery is understood to have taken place at buyer's end in following conditions. When buyer intimates the seller that he has accepted the goods. Okay, this is a very easy one. When buyer intimates in that, okay, I have received the delivery, I accept it. Done. Or does any act to the goods which is inconsistent with the ownership of the seller. Okay, he does something which goes against the ownership of the seller, like he consumes the goods. Okay, consumes, sells, use, alter, modify, damage, etc. He does any act. Okay, or there may be any other act like falling within these categories. So he does these acts. That means he has accepted the delivery. Definitely, when someone has accepted the delivery, then only he will resell it, or then only he will consume something. Otherwise, why would he do that? Okay, so this is called acceptance by conduct. Okay, when you intimate, this is earlier one is express intimation, express acceptance. This one is acceptance by conduct. The third one is acceptance by lapse of time. Okay, let me write in front of them. Express acceptance. Acceptance of delivery by conduct, and this is acceptance by lapse of time. Okay, like we discussed the example of Amazon or Flipkart sale. They say that you could return our goods to us within 30 days and we will not ask any questions and we'll refund the money, totally refund it. So in such cases, if the person retains the good beyond 30 days, okay, then definitely it means that he has accepted the delivery by lapse of time. And also, this lapse of time, this reasonable time depends on case to case basis. In some cases, it may be 1 hour, in some cases, it may be 30 days, in some cases, it may be 60 days. It depends upon the personal relations and personal contract, terms and conditions between the buyer and seller, or the circumstances surrounding the contract if there are no such written or implied conditions agreed between buyer and seller. Sorry. Rule number 15 and rule number 16. Give a quick look and then we will discuss it. Rule 15 is, that is contained in section 43. Buyer not bound to return rejected goods unless otherwise agreed. Where goods are delivered to the buyer and he refuses to accept them, having the right to do so, he is not bound to return them to the seller, but it is sufficient if he intimates to the seller that he refuses to accept them. Okay, that means it is upon seller to take back the delivery. It is seller's duty to recollect the rejected goods, meaning thereby that tomorrow, if a buyer has intimated to the seller that I do not accept the goods are damaged or this and that, and I do not acknowledge the delivery, then in that case it is the duty of seller to collect the goods back from the buyer. And if the seller fails to do so and something happens to the goods are damaged or goods perish out of time, then the risk shall be with the seller and buyer shall not be responsible if he has taken reasonable care of the goods. Okay, but goods damage out of the time or due to some natural event or unnatural event which is not within the control of buyer, then the seller shall be liable for that loss. 16, that is contained in section 44, liability of buyer for neglecting or refusing delivery of goods. Okay, when the seller is ready and willing to deliver the goods and request the buyer to take delivery. Okay, when seller is ready and he is willing to deliver as well and request the buyer to take the delivery, and the buyer does not within a reasonable time after such request take delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for the care and custody of the goods. Now this section says that if it is agreed Okay, when buyer is not providing him chance, now seller is contacting buyer that please provide me your address, I'll deliver it to you. Please provide me your address to home address or office address, or if any agent is there, or you do one thing, you collect it from my place and I'll pay the delivery charges and this and that. And still buyer keeps on delaying the delivery. He does not allow him to make that delivery. In that course, if some risk comes to the goods, then it is upon the buyer. Buyer shall suffer that risk. Why? Because he is the one who's at the fault, upon whose insistence or whose refusal or negligence the delivery is being delayed. And also, as well as tomorrow, if he accepts the delivery, he'll have to pay some charge, okay, to the seller for taking care of the goods, because now the goods belongs to buyer. And if somebody else is taking care of your goods, you must pay a reasonable charge. Provided, now this is an exception, provided further that nothing in this section shall affect the rights of the seller where the neglect or refusal of the buyer to take delivery amounts to a repudiation of the contract. It further says that, however, whatever may be written in this section, it shall not affect the rights of seller to treat the contract as cancelled. Okay, that means if seller wishes that there is a delay by the buyer or refusal by the buyer or neglect by the buyer to accept the delivery or allow him to deliver, then in that case, if seller wishes to treat the contract as repudiated and claim back the ownership of goods, he can do so. Now we will discuss unpaid seller. Okay, who's an unpaid seller? As the name suggests, okay, seller whose dues are yet to be paid by the buyer. Buyer has not paid the seller either in part or in full. Now, what are the rights of unpaid seller? Now, unpaid seller is given a special position in the law, and he has been, in order to protect a seller from being duped by the buyer, okay, so that buyer does not run away with the goods of the seller, okay, and does not pay him later on. Some remedies and some rights are provided to the seller by the law. This is called special protections or special privileges granted to an seller who is unpaid. Okay, these are allowed to seller who is unpaid either partly or fully. Now, what are these rights? Let's have a brief look and then we will discuss them in detail. So unpaid seller has two category of rights. One is against the buyer and then other one is against the goods. So what are his rights against the buyer? He can file a suit for the price. Okay, he can file a case for the price. He can file a suit for damages and suit for interest. Either all three or any one of them. And what are the right against the goods? Property in goods has, now right against the goods can be further declassified into two categories. When property in goods has passed to the buyer, that means when ownership has been transferred to the buyer, then he can exercise his right to lien or stoppage in transit or resale. Okay, or in the other case, when ownership has not passed to the buyer, he can withhold the delivery, he can exercise lien, he can stoppage in transit, or he can resale, he can do resale. So these are the rights of the unpaid seller. A contract comprises of reciprocal promises, as we all know. In a contract of sale, if seller is under an obligation to deliver goods, buyer has to pay for it. In case buyer fails or refuses to pay, the seller, as an unpaid seller, shall have certain rights. Okay, in case buyer refuses to pay, seller shall have certain rights. What rights are these? According to Section 45(1) of the Sale of Goods Act 1930, the seller of goods is deemed to be an unpaid seller. When is he deemed to be an unpaid seller? Let us see what is an unpaid seller. The whole of the price has not been paid, okay, or tendered, and the seller had an immediate right of action for the price. Okay, when whole price is not paid, okay, when the price in full, sorry. When a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it is received has not been fulfilled by reason of the dishonor of instrument or otherwise. Okay, now that means suppose just what check has been given and check has bounced, there is dishonor of instrument. Okay, it is either failed or failed to clear the bank scrutiny or has bounced or is dishonored. You may call either ways, but the financial instrument has failed to satisfy the seller. Then he will be an unpaid seller. The term seller here includes any person who is in the position of seller, as for instance, an agent of the seller to whom the bill of lading has been endorsed. That means seller means even the agents of seller. Okay, even the agents of seller are sellers, or a consigner or agent who has himself paid or is directly responsible for the price. That means a delivery boy or an agent, okay, or the agent of delivery boy or some other third party who has paid, they are all called, they are all a part of unpaid seller. They all can exercise these rights. Okay, now unpaid seller, sorry, I take my words back. Unpaid seller is one who is not paid in full, not in part. So now term seller, unpaid seller includes unpaid seller. Okay, unpaid seller. This term unpaid seller also includes seller himself plus his agents or any consignee who is having the delivery right now. Whose consignee is someone who is transporting it. Okay, transporter or people directly responsible to seller, like employees. Okay, employees are always directly responsible to employer, so they are all covered under the definition of unpaid seller. So all of them can exercise individually all the rights or any of the rights guaranteed to the unpaid seller by the act. Now let's do an example. X sold certain goods to Y for 50,000. Y paid 40,000 but fails to pay the balance. X is an unpaid seller. Okay, X is an unpaid seller. Why here X is an unpaid seller? Because X has not been paid in full. Okay, X is paid only part but not in full. P sold some goods to R for 60,000 and received a check of full price. On presentation, the check was dishonored by the bank. P is an unpaid seller because the check has bounced. Now, a bounced check has no meaning at all, no purpose at all in the law. It cannot satisfy even a single rupee. Forget about 60,000 rupees. So, that check is of no use to the seller. The seller remains unpaid seller. Now, what are the rights of an unpaid seller? Unpaid seller's rights, Section 46. Subject to the provisions of this Act and of any law for the time being in force, notwithstanding that the property in goods may have passed to the buyer, the unpaid seller of the goods, as such, has by implication of law. Now let us read it one by one. Subject to the provisions of this Act. That means other provisions of this act shall also be read when considering a seller's right. Okay, other provisions shall be read and any law for the time being in force if some other law is applicable to the parties, like law of arbitration. Okay, notwithstanding that the property in goods may have passed to the buyer. Okay, even if, notwithstanding means even if the ownership has passed on to the buyer, then also unpaid seller has by implication of law. That means law provides, okay, that means law assumes that unpaid seller will have all these rights. Okay, so now unpaid seller will have all these rights. Let's read these, give it a quick reading and then we will discuss them. Now what are these rights? A lien on the goods for the price while he is in possession of them. Lien means lien is equal to charge. That means seller can retain the goods belonging to buyer if not paid. That means seller can retain the goods. A lien on the goods for the price while he is in possession of them. In case of the insolvency of the buyer, suppose buyer has, before the goods have been delivered, buyer has become bankrupt. Okay, in this case, a right of stopping the goods in transit after he has parted with the possession of them. A right of stopping the goods in transit. In transit means goods are now in mode of transport. Okay, and definitely when the goods are now in mode of transport, he has parted with the possession of them. Okay, the possession is no longer with the seller. Who has the possession? The delivery guy or the transport carrier. He has the possession, not the seller. A right of resale as limited by the act. He can resell those goods. These are the three rights. He can resell those goods as per the rights granted by the act. Okay, whatever power this act provides him for reselling, he can use those acts, those rights. Sorry. Where the property in goods. Now, this is where the property in goods have passed to the buyer. That means ownership has transferred to the buyer. Then he has these rights. Now let us read. Where the property in goods has not passed to the buyer, the unpaid seller has, in addition to the other remedies. Unpaid seller has, in addition to his other remedies. Okay, in addition to his other remedies. What are other remedies given above? Okay, that means whatever now we are going to read is additional to him. Okay, a right of withholding delivery similar to and coextensive with his rights of lien and stoppage in transit where the property has passed to the buyer. Okay, that means he'll have just similar rights other than all other rights. Okay, he has similar rights. What other rights he could have? He can like file a suit for the breach of contract. He can file a case for damages. Other than that, he can withhold the delivery. He can refuse to deliver the goods. Okay, he can exercise lien and he can also exercise the right of stoppage in transit. Okay, where the property has passed to the buyer. I mean, just like whatever rights he has when the property has passed to the buyer, he has similar rights in case the property has not passed to the buyer, in case the ownership has not been transferred. Okay, and this is in addition to other remedies. What other remedies could be there? He can file case for the breach of contract, he can file case for the interest, he can file case for the damages, etc., like we have discussed in the law of contract. An unpaid seller has been expressly given the rights against the goods as well as the buyer personally, which are discussed as under. Okay, his rights are discussed as under. Now, these are rights of unpaid seller, rights of unpaid seller against the goods. Give a quick look and then we will discuss it. Okay, now right of unpaid seller against the goods. A. Rights of an unpaid seller against the goods. The right of unpaid seller can be categorized in two headings. Okay, in two headings. Now let us read what are the headings. First is seller's lien. Seller's lien, like we discussed, lien is Lien is refusing to deliver the goods. Okay. Okay. Lien is just holding the goods with himself. That is in section 47. According to subsection 1, 47.1, subject to the provisions of this act, the unpaid seller of goods who is in possession of them, okay, for exercising the right to lien, seller, okay, this right to lien means withholding of goods, refusing to deliver the goods. This right to lien by the seller can be exercised only upon one condition, that he must have the possession of goods. Okay, he must have. If he has lost the possession of the goods, the right to lien is also lost with the possession. So, right to lien is occurs only with possession. Right to lien occurs only with possession. So, the unpaid seller of goods who is in possession of them is entitled to retain possession. Okay, he is entitled to do what? He is entitled to retain possession of them until till what stage can he retain the possession? Until payment or tender of the price in the following cases. Payment means when the payment has actually been made. Tender means offer to pay. When buyer makes an offer to pay the price, okay, and he accepts it. Now, in following cases, he can exercise the right to lien. Okay, in what cases can he exercise the right to lien? In following cases, let us read the cases. Where the goods have been sold without any stipulation as to credit. Credit means loan. Okay, when goods have been sold without any stipulation as to credit, that means when he has sold the goods on direct cash payment, not on loan. When he has sold the goods on loan, that itself means that price will be paid on some other date, or in EMIs, or in installments, or in some other fashion. Okay, if he has sold the goods on loan, then he cannot exercise the right to lien, because he will be definitely paid later on. But if he has sold the goods in direct cash or same day transfer, or payment against a ready payment, then he can exercise the right to lien, not in case when he has sold the goods on credit or loan. Where the goods have been sold on credit. Okay, now suppose goods have been sold on credit, but the term of credit has expired, but the time period for repayment of the loan has expired. Time period for repayment of loan has expired, then he can exercise the right of lien. Okay, when he has sold them against that payment, then, and if he has sold them on credit, then the right to the time period for repayment has expired, or where the buyer becomes insolvent. Where the buyer becomes insolvent. become bankrupt. Like A has to deliver goods to B on next month in Jammu. In Jammu and Kashmir. A is in Tamil Nadu. Meanwhile, A comes to know that B has become bankrupt. When B has become bankrupt, that means B will not pay for the goods now. B cannot pay. Obviously, when someone has become bankrupt, that means he has no money left. So when someone has no money left, why would seller send his goods to the such person who is not going to pay? In that case, he can exercise his right called seller's lien. He can retain the possession of goods and refuse to deliver it to the buyer unless price is paid. According to subsection 2, the seller may exercise his right to lien, notwithstanding that he is in possession of goods as agent or bailey for the buyer. Okay, he can exercise his rights to lien even when he is an agent, agent of the seller. Okay, or bailey for the buyer. He is a bailey for the buyer. Okay, that means goods are lying with a bailey. Okay, sorry, goods are not lying with the Bailey, but he is acting as a Bailey now. Okay, we discussed a situation in which seller may become a Bailey when the ownership has transferred. Okay, but the goods are still lying with the seller. In that case, seller becomes Bailey. Okay, but he is still an unpaid seller as well as Bailey. He is taking care of the goods. Then also he can exercise his right to retain the property. Now let us discuss part delivery, that is in section 48. You give a quick look and then we will discuss the part delivery and termination of lien. Part delivery, that is section 48, where an unpaid seller has made part delivery of the goods. Part delivery means half of the goods are delivered. Okay, like suppose he is to deliver 100 goods and he has out of 100, suppose out of 100, seller has delivered 40 pieces or articles. Okay, he has delivered 40 pieces or articles. He may exercise his right to lien on the remainder. Okay, now because we discussed that right to lien is available only on the goods on which possession is still with the seller. So now that means he has delivered 40 pieces. Now he cannot exercise lien on the 40 pieces because he does not have the possession of those 40 pieces. But he still has 60 pieces left. He could exercise his right to lien on those 60 pieces. Okay, so he can exercise his right to lien on those 60 pieces. Part delivery. This is the case of part delivery. Unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. Okay, he may unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. Okay, he cannot exercise his right to lien on those 60 pieces which are in possession right now in such circumstances which show that he has waived off his right to lien. Okay, he has waived off his right to lien. When can these circumstances be? Like he gives in writing that I will not exercise my lien. He gives in writing, or he tells him that I will not exercise lien on the rest of the articles which are lying with me. Okay, then in that case, his right to lien will go away. According to, now we'll do termination of lien. When this right to lien is right to retain possession will get terminated. Okay, when this lien will come to an end. Let's read it. According to subsection 1, the unpaid seller of goods loses his lien. When will he lose his lien thereon? When he delivers the goods to a carrier. Okay, when he delivers the goods to a carrier or other bailee for the purpose of transmission to the buyer without, without reserving the right of disposal of the goods. Okay, when he has delivered the goods to a carrier is a, when the carrier is a third party. Okay, third party like railway, train, or shipping yard, he has delivered the goods to them for transporting it to the buyer. That means now goods have gone out of the possession of the buyer, and lien can be exercised only when he has the possession of the goods. So when the possession is lost, right to lien is lost. This is a simple rule. Okay, lien occurs only with the possession. If there is no possession, there is no lien. So now when the possession is with the carrier, when the possession is with the train, ship, truck, or plane, or any other person, courier guy, then he cannot definitely exercise his right to lien, provided if he has delivered the goods to the carrier with reserving the right of disposal of the goods. We discussed this situation that when seller reserves the right to disposal of the goods, then it is understood that seller still holds the possession of the goods. That means it is only seller who will accept the delivery at the other part of the transport also. So that means seller still has the possession of the goods in this case. Okay, otherwise if he does not reserves his right to disposal of the goods, once the possession is lost, it is lost forever, and he cannot exercise lien. When the buyer or his agent lawfully obtains possession of the goods. Okay, now other situation is when the buyer or his agent or the agent of buyer, they have lawfully obtained the possession of the goods. Lawfully, the term is lawfully, not unlawfully. Okay, it is not that buyer can illegally enter into the godown of the seller, crack open the doors, and then run away with the goods. No, this cannot be the case, and buyer cannot claim the delivery of the goods following illegal means. He can only lawfully, when he is getting the delivery in legal ways, he has taken the possession of the goods legally, lawfully, then only the right to lien is lost. Why? Because the possession is with the buyer and seller has lost the possession by waiver thereof. When he waives it, when he waiver means you give up, when he gives up his right to retain the goods. When he gives up, he can give his right to retain the goods either orally or through his conduct, okay, or through written means. Either ways he can waive off his right to have his lien. These are the ways in which the right to lien will get terminated. The unpaid seller of goods having a lien thereon does not lose his lien by reason only that he has obtained a decree for the price of goods. Okay, that means simply because he has filed a case and he has won the case and court has ordered the buyer to pay the price, that does not mean that he'll now have to deliver the goods. He can still keep the goods till the time price is not paid. That means till the time court's order is obeyed by the buyer. Okay, now you may be thinking why buyer will not obey the order of the court. It may be because buyer may go into the appeal against that order and he may challenge that order. Okay, so that ways, even if there is an order, till the time he is not paid as per the order, right to lien will not terminate automatically because he has now gotten decree of price. Rights of lien. An unpaid seller has a right to lien on the goods for the price while he is in possession until the payment or tender of the price of such goods. It is the right to retain the possession of the goods and refuses to deliver them to the buyer until the price due in respect of them is paid or tendered. The unpaid seller's lien is a possessory lien. The lien can be exercised as long as the seller remains in possession of the goods. This is just the crux or the gist of what we have discussed above. Let's proceed ahead. Now, how the right to lien can be exercised. You give it a quick look and then we will discuss further. Now, this right can be exercised by him in the following cases only. Okay, where goods have been sold without an stipulation of credit, like we have discussed, where goods have been sold on credit but the term of credit has expired, where the buyer becomes insolvent. We have discussed all these situations, so we'll not spend much time on it. Let's read the example. A sold certain goods to B for price 50,000 and allowed him to pay the price within 1 month. Okay, 1 month credit, that is 1 month credit, sale on credit. B becomes insolvent during this period of credit. A, the unpaid seller, can exercise his right to lien because still the period of credit is with the buyer but he has become insolvent meanwhile. So when someone has become bankrupt, you cannot expect him to pay even within a month. Okay, so this is situation one. Seller may exercise his right to lien even before he is in possession of the goods as the agent or bailee. Okay, sometimes seller may act as an agent of the buyer or a bailee of the buyer when the transfer of ownership has taken place. Okay, when buyer has become the owner but the goods are still lying with the seller, in that case seller is only acting as an agent of the buyer or a bailee of the buyer, but because he has the possession he can still use his right to lien. The term insolvent refers to a person is said to be insolvent who has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether he has committed an act of insolvency or not. Okay, when someone has failed to pay his debts, he has become insolvent. Now, how the termination of lien will happen, we have discussed it. Okay, when he delivers the good to carrier, or when the buyer has lawfully obtained the possession, or when the seller has waived of the right to lien. The fourth one is by estoppel. Okay, by estoppel, he can also lose his right to lien by way of estoppel. Estoppel means you are stopped by the law. So, where the seller so conducts himself that he leads third parties to believe that lien does not exist. When his conduct is such that other parties believe that he does not exercise or he has waived his right to lien, then he cannot exercise his right to lien. What is the exception to this section? Let us read. The unpaid seller of the goods, having a lien thereon, does not lose his lien by reason only that he has obtained a decree for the price of goods. We have discussed just because he has taken a decree, it does not mean that he'll have to hand over the possession as well. He'll hand over the possession only and only when the price is paid, come what may be the order of the court. Now let's do an example. A sold a car to B for 1 lakh rupees and delivered the same to the railways for the purpose of transmission to the buyer. The railway receipt was taken in the name of B and sent to B. Now A cannot exercise the right to lien. This is two. There are two things involved here. Why? Because first he has lost the possession because he has taken the receipt in the name of B, and now B has right to collect the goods from car from the railway, plus by his conduct he has implied that he does not exercise his right to lien. Okay, this is an estoppel as well as an act of losing of possession. So now in these cases the right to lien of a seller, of an unpaid seller, sorry, will come to an end. Now let us see what other right he has. The other right which an unpaid seller is right to stoppage in transit. Let us see what this right to stoppage in transit is. Give it a quick look and then we will discuss it. Now, what is a right to stoppage in transit? We have discussed what is a transit. Transit means when something is in the mode of transport. Okay. Right of stoppage in transit, section 50. Subject to the provisions of this act when the buyer of goods become insolvent. Now, when this right will become will be activated when the buyer of the goods have become insolvent. This is the overriding condition. If the buyer of the goods have not become insolvent, the right to stoppage in transit will not accrue to a seller. He will not get this right. He'll get this right only and only when when he has when the buyer has become insolvent. The unpaid seller who has parted with the possession of the goods. Okay, now what we are discussing, the unpaid seller who has parted with the possession, because the goods are in mode of transport, definitely he has lost his possession and the possession is with either railways or any other third party who is carrying the goods. Okay, who has parted with the possession of goods has the right to stop them in transit. That means seller can stop them in the transit. He can stop them. Okay, he can call the truck driver that you please stop, do not make the delivery, or he can give the instructions to the railway manager that not to deliver the goods. That is to say, he may resume possession of the goods as long as they are in the course of transit and may retain them until paid or tendered price of goods. That means if within the mode of transport the buyer has become insolvent and before the delivery is made to the buyer or his agent, he can stop the transit. Somehow he can stop the transit or he can stop the delivery. Then he can reclaim his right to lien. He can reclaim his possession, not otherwise. Now let us see what is the duration of transit. When can the goods be understood that they are still in transit? Okay, now there comes a question that when can seller stop the transit? Okay, when can the goods can be assumed that they are in the mode of transport or they are delivered or not delivered? Let us read. Goods are deemed to be in the course of transit from the time when they are delivered to a carrier or other bailey for the purpose of transmission to the buyer until the buyer or his agent in that behalf takes delivery of them from such carrier. That means till the time, the moment they are delivered to the carrier and till the time the buyer does not take it, this is they are considered to be in transit, whether the transit is moving or not. Okay, you deliver it to a truck and truck is supposed to deliver within 15 days, but truck breaks down and truck is passed on some highway for 30 days, truck is not moving even an inch, then also the goods will be in the transit. Okay, after losing of the possession by seller and before gaining of the possession by buyer, whatever is happening in between is transit. Okay, the goods are assumed to be in transit. If the buyer or his agent in that behalf obtains delivery of goods before their arrival at the appointed destination, the transit is at an end. Okay. Now suppose the goods were to be delivered in Delhi, but the truck was meanwhile truck was in Madhya Pradesh and some agent of the buyer has stopped the truck in Madhya Pradesh and taken the delivery for buyer, the transit will come to an end. That means the moment a buyer or his agent takes the possession of the goods, the transit will come to an end. If after the arrival of goods, okay, if after the arrival of goods at the appointed destination, the carrier or other bailee acknowledges to the buyer or his agent that he holds the goods on his behalf and continues in possession of them as bailee for the buyer or his agent, the transit is at an end and it is immaterial that further destination for the goods may have been indicated by buyer. Okay. Now this is the second situation is when buyer has or his agent has taken the control. Third situation says when Okay, the transit will come to an end. Why we are discussing this transit? Okay, because it is very much relevant to understand that seller will have right to lien only when he has a possession. Okay, it is not the case that buyer has the possession. Okay, and seller goes and snatches those goods from the buyer. Okay, he cannot take the goods out of the custody of the buyer once the buyer has gained the possession. If the buyer does not willingly himself offer the custody to the seller, seller cannot take the goods back from the buyer in any case. So that is why we are discussing this transit, that he can reclaim his right to lien during the transit by stopping the transit. But at what time can he stop the transit? Now suppose the carrier has acknowledged that I am carrying the goods for the buyer, and he intimates the buyer that I am carrying these goods for you. And after that, and before the actual delivery to the buyer, if the seller wants to stop the truck and reclaim the goods, that would be an illegal act, because he has now lost his right to stoppage in transit. Okay, he cannot seller cannot exercise the lien once the goods have gone to the possession of buyer, even if they are, suppose the goods are lying into the godown of the buyer and buyer is not there, the godown is lying open, then also seller cannot go and take the goods back. That would be illegal. Seller can have lien, seller can claim the goods only and only if they are in his possession or in the possession of third party like carrier. But when the third party acknowledges that it is carrying those goods for the benefit of buyer, then the right to stoppage in transit will come to an end, and buyer cannot stop that carrier and claim the goods from him. That will be illegal. If the goods are rejected by the buyer and the carrier or other bailee continues in possession of them. Now, if the goods are rejected by the buyer, okay, the carrier or other bailee continues in possession of them, the transit is not deemed to be at an end even if the seller has refused to receive them back. Now, the buyer has not taken the goods, buyer has rejected the goods, and even seller refused to take them back. Okay, the goods would be assumed to be still in the transit. The goods would be still in the transit. Okay, transit will not come to an end. That means if any of the party now, suppose now buyer has refused the goods and the truck goes back to the seller. Now seller also refused to take the goods. Now that means goods are still in the transport, and at this moment any party may still want to take possession. It can take, if the seller wants to take possession, he can take it. If the buyer wants to take the possession, he can still take it. Okay, so the transit will not come to an end till the time the goods have been delivered to the buyer, or it is acknowledged that he is holding the goods for the buyer, or the transit has been stopped by the seller. Otherwise the transit will continue to be so. When the goods are delivered to a ship chartered by the buyer, it is a question, depending on the circumstances of the particular case, whether they are in possession of the master as a carrier or as agent of the buyer. Okay. Now suppose the goods are delivered to a ship which is chartered by the buyer. Okay. The ship is arranged by the buyer. Ship is arranged by the buyer and the seller delivers the goods to the ship. Now it depends. Now there are two questions. Okay, now you forget ship, it may be a truck as well. That buyer sent his truck. Buyer sent some truck to collect the delivery from the seller, or he sent a plane, or he sent a ship, or he sent a special train. Okay, in any case, now delivery is taken by the buyer. Buyer has sent his person to take it. Now, whether it will be still a transit or not, it will depend on two situations. What are those two situations? Let us discuss. If the carrier or say master of the ship or captain of plane. Okay, now suppose there are two conditions. If the carrier or the master of ship or truck driver or the driver of the train or the captain of the plane, if these people are holding these goods, if they have taken the possession of the goods which they are supposed to deliver to the buyer in their individual capacity, if he is acting as a master of the ship or the driver of the truck, then it is transit and seller can still stop the transit before the delivery is made to the buyer, even though the fare is paid by the buyer, even though the train, plane, or truck or ship is arranged by the buyer. But if they are holding the goods in the independent capacity, okay, then the goods are still in transit. Okay, but if they are acting as an agent of the buyer, the moment goods are loaded on their train, plane, truck, ship, the transit is lost. Okay, the transit is lost. If they are acting as an agent, the transit is lost. If they are acting in their individual capacity, transit will continue. Where the carrier or other bailee wrongfully refuses to deliver the goods to buyer or his agent in that behalf, the transit is deemed to an end. Okay. Now, suppose the captain is holding the ship and the goods in his individual capacity, and he is arranged by the buyer. But now buyer has paid him his fare. Okay, but he illegally refuses to deliver the goods to buyer. The transit will come to an end the moment he his illegal actions begin. Okay, the moment his illegal actions begin, the transit will come to an end. Why? Because he is duty bound to deliver the goods to the buyer, because he has paid the price for the transport. He has no authority, because the right to claim or right to retain the goods is only with the seller, not with the carrier. The right to retain the goods can only be with the seller. The lien can be exercised only by the seller, not by the transporter. And if the transporter illegally refuses to deliver the goods to the buyer, the transit will come to an end. Now, at this moment, the goods may still may be with the transporter, but the seller cannot claim his lien now. Even if the goods are still with the truck driver, he has illegally refused to deliver the goods with the to the buyer. The possession is lost. Seller cannot call it a transit and reclaim the goods from the transporter. No, that can't be done. The transit has come to an end the moment he illegally refuses to deliver the goods to the buyer. Where part delivery of goods has been made to the buyer or his agent in that behalf, the remainder of the goods may be stopped in transit. Okay, unless such part delivery has been given in such circumstances as to show an agreement to give up possession of whole of the goods. Okay, unless it is shown that by giving some part of the goods, you have made a you are waiving your right to other portion as well. Okay, then the whole possession is lost. But if you have not given such indication and you are still having part goods with you and part of the goods you have delivered, so you seller can exercise lien on the whatever goods are left with him. Okay, whatever goods are left with him, unless he has shown that by making delivery of other part, he has given up his right to lien on whole part, even on the remainder as well. Okay, this was all about right to stoppage in transit. How stoppage in transit is affected. How stoppage in transit is effective. You give it a quick look and then we will discuss how you have to, now you have a right to stoppage in transit, but how do you exercise your right to stoppage in transit? How a seller will exercise his right to stoppage in transit? Give it a quick look and then we will come back to discuss. Now let's read. The unpaid seller may exercise his right to of stoppage in transit. How? How can he exercise his right to stoppage in transit? Either by taking actual possession of goods. Okay, one is either by taking actual possession of goods. That is just like saying, suppose the goods are lying in the truck, he'll stop the truck and he'll unload the goods and will take the physical possession of the goods. One thing. Or that is other, by giving notice of his claim to the carrier. He can give notice of his claim to the carrier. That is, okay, he intimates it to the carrier that do not deliver the goods to the buyer or other bailey in whose possession the goods are. Okay, or to other bailey, suppose goods are lying in the godown of some third party, he can tell, he can give it a notice to the transporter or the bailey that I do not want the goods to be delivered to the buyer. The right to stoppage is affected, or he can himself go, or his agent can himself go and physically take the goods back from such transit and take it back. In these cases, the right to stoppage in transit is affected. Such notice may be given either to the person in actual possession of the goods or to his principal. Like it can be given either to the truck driver who is carrying the goods, or the train driver. Okay, or maybe to his principal. Who can be his principal? Like the owner of the truck. Okay, driver is merely an employee of the owner. He can tell it to the owner of the goods, or he can tell it to the manager of the railway, or he can tell it to the owner of the ship company. Okay, either to the driver or his owner. In the latter case, the notice to be effective shall be given at such time and in such circumstances that the principal, by the exercise of reasonable diligence, may communicate it to his servant or agent in time to prevent a delivery to the buyer. Okay, but when you are giving instructions intimating your that you are exercising your right to stoppage in transit, when you are intimating this to the principal or to the owner and not directly to the person who is holding the goods, then you should do it in such a manner that it allows reasonable time to the owner to communicate your instructions to his employee. Okay, it is not that he is about to deliver in 2 minutes and then you tell to the owner that you please stop him, and meanwhile the owner calls the agent, the goods are already delivered. No, it cannot be done in a very quick fix manner. You have to give the reasonable time to the principal to forward your instructions to the one who's holding the goods on behalf of that principal. When notice of stoppage in transit is given by the seller to the carrier or other bailee in possession of goods, he shall re-deliver the goods to or according to the directions of the seller. The expense of such re-delivery shall be borne by the seller. Now the act mandates it that if the seller has intimated to the carrier or the other bailee or the owner that I exercise my right to lien and I stop this transit, then it is duty bound. Then the carrier is duty bound to deliver the goods back to seller, and he cannot deliver the goods to the buyer. If he delivers the good to the buyer, then the carrier will be at fault and he'll have to probably pay for the goods. He shall re-deliver. Okay. He is bound to re-deliver the goods to the buyer, to the seller, sorry. Meaning of the right of stoppage in transit. We are trying to now analyze this section. Let us do it. The right of stoppage in transit means the right of stopping the goods while they are in transit, to regain the possession and to retain them till the full price is paid. Okay, right to stoppage is you can stop till the time full payment is made. When the unpaid seller has parted with the goods to a carrier and the buyer has become insolvent. Okay, when he has delivered the goods and meanwhile the buyer has become insolvent, buyer has become bankrupt, he can exercise this right. So now I again make it clear that he can exercise the right to stoppage in transit only in case when the buyer has become insolvent. Otherwise he cannot validly stop a transit. He can exercise this right of asking the carrier to return the goods back or not to deliver the goods to buyer. Okay. This right, what right is this? This right is merely an extension of the right to lien because it entitles the seller to regain possession even when the seller has parted with the possession of goods. Okay, now in a sense, this right is just an extension of the right to lien because the right to lien comes to an end when he has parted with the possession. So this right allows him to reclaim the possession. That means this is just a extension of his right to lien because after getting the possession he'll again ultimately what seller will do, he will ultimately exercise his right to lien only. However, the right of the stoppage in transit is exercised only when the following conditions are fulfilled. Okay, now these are the conditions which must be fulfilled in order for the buyer to exercise his right to stoppage in transit. What are these conditions? We have already done them. Let us give it a quick brief look. Okay, the first one is the seller must be unpaid. Definitely he has to be unpaid, otherwise he has no cause of action to stop the transit. He must have parted with the possession. Definitely he should have handed over the goods to third person without reserving his rights of disposal. Okay, without reserving his rights of disposal, he must have parted with the possession of goods. The goods are in transit, and the goods are in transit, that means transit has not come to an end. And we have discussed what is transit and at what point of time transit comes to an end. So transit has not come to an end. The buyer has become insolvent. This is very critical point. It is not that simply any unpaid seller can stop the transit just because he is not paid it or he feels that buyer will not pay him. He cannot exercise this right to stoppage in transit. Only and only he can exercise this right of stoppage in transit is when the buyer has become insolvent, when he comes to know that buyer has become a bankrupt. Okay, and what is a bankrupt? When in the ordinary course of business a person has failed to repay his debt, whether officially he has been declared insolvent or not. When we are discussing insolvent here, we are not discussing an insolvent who has been declared insolvent by the court of law. No, if his check has bounced or if he has failed to meet his financial obligation, then he is declared insolvent. That's it. The right is subject to provisions of the act. Definitely, because the right is granted by the act, so it is going to be subject to the provisions of the act. No need to explain this. Now let us read an example for this. B. At Delhi. This part is just somehow a repetition. It has, I don't know how it has come here, so I'll just delete it so that we do not have to unnecessarily redo it. B is a seller who is at Delhi, orders goods of A. No, B is a buyer, sorry. B at Delhi orders goods of A at Mumbai. A is at Mumbai. A consigns and forwards the goods to B. Okay. On arrival at Delhi, they are taken to B's warehouse and left there. B refuses to take these goods and stop payment. The goods are in transit and the unpaid seller can take them back. Now, though the goods are in B's warehouse, okay, they are in the buyer's warehouse, but buyer refuses to take the delivery. The goods will still be deemed to be in transit, and now seller can go to the B's warehouse and collect the goods back. Okay, because he has a right to reclaim the goods when the goods are in transit and the transit has not ended because buyer has refused to accept the delivery. What is the duration of transit? The goods are deemed to be in the course of transit from the time when they are delivered to carrier or other bailee for the purpose of transmission to the buyer until the buyer or his agent in that behalf takes delivery of them from such carrier or other bailee. Okay, the moment he loses the possession and hands the goods to third party for delivery. Okay, until the time that third party delivers the goods to buyers or acknowledges that it holds those goods to buyer, the transit will continue. It does not matter how many days, months, or years it may continue. Now we will do distinction between right of lien and right of stoppage in transit. Give it a quick look of these four differences and then we will discuss them. Now, the essence of a right to lien is to retain the possession. Okay, what is the essence of right to lien is? It is to retain the possession. You have a possession, you will retain it. This is the essence of right to lien. Whereas the right to stoppage in transit is right to regain possession. Okay, now right to lien is that you are retaining the possession. You have a possession and you are retaining it. You are not parting with it. But right to stoppage in transit is that you have lost the possession and now you are reclaiming it. Okay, so in one case you are continuing a possession, in the other case you are reclaiming a possession. So this is the first distinction between these two. The second one is seller should be in possession of the goods under lien while in stoppage in the transit. Now, while in stoppage in the transit, these Three conditions should be there. Seller should have parted with the possession. Possession should be with the carrier. Buyer has not acquired the possession. Now this is a distinction on basis of possession. Okay. Now, if in order to exercise the right to lien, seller should have the possession. If he does not have possession, he cannot exercise right to lien. But while stoppage in transit, there are three conditions he has to fulfill. What are the conditions he has to fulfill to exercise the right to stoppage in transit? Is that he should have delivered the possession to a third person, to a carrier, and possession should be with third person, and the third person must not have delivered the goods to the buyer. If these conditions are fulfilled, he can exercise right to stoppage in transit. If he has the possession, he has not parted with the possession, he can exercise right to lien. And if the possession is lost to the buyer, he cannot exercise any right at all. Right to lien can be exercised even when buyer is not insolvent. Right to lien definitely can be exercised even when buyer is not insolvent. Okay, he is merely refusing to pay, but he is still solvent. Then also you can exercise, a seller can exercise right to lien. But in the case of stoppage of transit, he can stop the transit only in case when the buyer has become insolvent and not otherwise. The right of stoppage in transit begins when the right of lien ends. Okay, right of stoppage in transit begins when right of lien ends. Why? Because right of stoppage begins only with when the possession is lost. So when the possession is lost, the right to lien is lost, because the right to lien occurs only with possession. Thus, the end of the right to lien is the starting point of the right to stoppage in transit. Okay, this is a very famous keyword, and it may be asked in the questions that explain the statement that the end of the right to lien is the starting point of the right to stoppage in transit. So you have to explain it the way we are discussing it here. Effects of the subsale or pledge by buyer. What will be the effect of a subsale or pledge by the buyer? Now, what is a subsale or pledge? Subsale or the pledge means goods are still with the seller, but buyer has already sold them to third party, or buyer has kept them as a security to third party. Now, what will be the effect of this act upon the rights of the unpaid seller? Let us read. The right of lien or stoppage in transit is not affected by the buyer selling or pledging the goods unless the seller has assented to it. This is based on the principle that the second buyer cannot stand in a better position than his seller. Now, we discussed somehow in earlier chapters that defective title, defective person can deliver only a defective title. So, though the goods are with the seller, but buyer has sold it to a third party or pledged it or kept it as a security to third party, still the third party will not get any right over the goods. Why? Because seller has not consented to it, and seller can still exercise his right to lien, as well as if he has lost his right to lien, he can exercise his right to stoppage in transit, irrespective of the fact that seller has conducted a buyer has conducted a sub sale or pledge. The right to stoppage is defeated if the buyer has transferred the document of title or pledges the goods to a sub-buyer in good faith and for consideration. Okay, but the right to stoppage in transit will be defeated if the buyer has transferred the document title, because if you do not have the documents of title, how can you stop the transit? Seller cannot stop the transit without the document showing ownership of the goods. So when the ownership of the goods and the documents are transferred, definitely right to stoppage in transfer transit is lost. Let's do an example. A sold certain goods to B of Mumbai, and the goods are handed over to railways for transmission to B. In the meantime, B sold these goods to C for consideration. B becomes insolvent. A can still exercise his right to stoppage in transit. Okay, now C must claim the money back from B if he can at all, but he cannot file a case against A that you hand over the goods to me, because A has exercised his right to stoppage in transit because A is unpaid seller and his right is not defeated because just because B has sold it to C. Exception is when the seller has assented to the sale, mortgage, or the other disposition of goods. But yes, if seller has accepted it, then nobody can question it. A entered into a contract to sell cartoons in possession of Warfinger to B and agreed with B that the price will be paid to A from the sale proceeds recovered from his customers. Now A says that I sell my goods to you, to B, but you will not pay me, but you will pay me only when you will sell it to your customers, and when you will receive payment from your customers, you will pay me. Now B sold goods to C and C duly paid to B. But anyhow, B failed to make the payments to A. Okay. A wanted to exercise his right to lien and ordered the Warfinger not to make delivery to C. Held that seller had assented to the resale of goods to the buyer by the buyer to sub buyers. As a result, A's right to lien is defeated. Okay, this is the case. In this case, now A said that you do one thing, you sell it to your buyers, and when your buyer will pay you, you pay the money to me. That means he is assenting to the sub sale by the buyer without payment. So now when he has sold it and he refuses to pay, then he cannot exercise right to lien because he has now in good faith and validly made a purchase. When a document of title to goods has been transferred to the buyer and the buyer transfers the documents to a person who has bought goods in good faith and for the value for the price, then the provision of subsection 1 stipulates as follow. Now when the documents are transferred to buyer and buyer transfers these documents to C or to third party who in good faith buys it, then following rules will apply. If the last mentioned transfer is by way of sale, right of lien or stoppage in transit is defeated. Okay. If the last mentioned transfer is by way of pledge, unpaid seller's right to lien or stoppage only be exercised subject to the rights of pledgee. Okay. If it is only a pledge, then first of all he'll have to pay the money back to the pledgee and then only he will take the goods. However, the pledgee may be required by the unpaid seller to use in the first instance the other goods or securities of the pledger available to him to satisfy his claims. Okay. Effects of stoppage. The contract of sale is not rescinded when the seller exercises his right to stoppage in transit. The contract still remains in force and the buyer can ask for delivery of goods and payment of price. Just because the transit has been stopped by the buyer, by the seller, it does not mean the contract has come to an end. The contract is still commencing and buyer can still pay the price and claim the goods. Now, what is a right of resale? That is section 54. Right of resale. Right of resale is with whom? Right of resale is with the unpaid seller. Resale means I have made a sale to the buyer, but he has not paid it to me, but the sale is complete. So I have exercised my right to lien and he refuses to pay me within a reasonable time. Then I can resell the goods to third party. That is right of resale. Let's read it. The right of resale is very valuable right given to an unpaid seller. In the absence of this right, the unpaid seller's other rights against the goods, that is, lien and stoppage in transit, would not have been of much use because these rights only entitle the unpaid seller to retain the goods until paid by the buyer. See, these rights, right to lien and right to stoppage in transit, are not going to be of any value to the seller if we do not give him a right to resell, because if he cannot resell, what good is the possession for him? What he'll have to ultimately take care of the goods of the buyer only. He'll run the risk. If he cannot resell the goods, what good will the possession do to him? He is just holding the goods, but he cannot sell them, and buyer is not paying, then what is the purpose of retaining the goods? Ultimately, goods will lose their value. Okay, and the seller will suffer a loss. So the law says that you can exercise your right to lien or stoppage in transit, and if within reasonable time the buyer does not pay you, you can conduct a resale, and it's a very prized right of the seller, unpaid seller. The unpaid seller can exercise the right to resell the goods under the following conditions. Where the goods are of a perishable nature, in such a case the buyer need not to be informed of the intention to resell. Where the goods are of perishable nature, they are going to quickly decompose, and there is no time to inform the buyer, then he can just resell if the price is not paid. Where he gives notice to the buyer of his intention to resell the goods, where he gives notice to buyer that if you do not pay me by that date, I will resell it to someone else. If after the receipt of such notice the buyer fails within a reasonable time to pay or tender the price, the seller may resell the goods. It may be noted that in such cases, on the resale of goods, the seller is also entitled to. Now, after the resale, seller is also entitled to further rights. What are those further rights? He is first right is he can conduct a resale. Now he has conducted a resale. Now, other than this resale, no, sorry, addition to this resale, he can also do what? Let us read. He can also do recover the difference between the contract price and resale price from the original buyer as damages. Now suppose originally the price was 100 rupees agreed between the seller and the buyer, but buyer did not pay within a reasonable time, and by the time seller conducted a resale the price had gone to 60. Now he will recover 40 rupees from the buyer. Okay, now he can not only conduct a resale, he has conducted a resale, taken 60 rupees from the market, but he has lost 40 rupees due to the lapse of buyer, then he can claim 40 rupees from the buyer. Retain the profit if the resale is higher than the contract price. Suppose contract price was 100, but now he has resold them for 150 rupees, then he is not required to repay those 50 rupees to buyer, he can retain it. It may also be noted that seller can recover damages and retain the profits only when the goods are resold after giving notice of resale to the buyer. Okay, he can recover damages or retain the profit only when he has given the notice. Okay, only when he has conducted a resale after giving the notice. If he has not given the notice of sale to the buyer and conducted a sale and made some profit, then he must give the profit back to the buyer because the property belonged to buyer. Thus, if the goods are resold by the seller without giving any notice to the buyer, the seller cannot recover the loss suffered on resale. Moreover, if there is any profit on resale, he must return it to the original buyer. He cannot keep such surplus with him. Where any unpaid seller who has exercised his right to lien or stoppage in transit resells the goods. The subsequent buyer acquires the good title thereof as against the original buyer, despite the fact that notice of resale has not been given the seller to the original buyer, even when the notice has not been given. Okay, now in that case, what will happen? He cannot claim the loss or he cannot keep the surplus, but the third party to whom he has resold the goods will get a good title. Buyer cannot reclaim the goods from C, claiming that the sale was illegal. Okay, sale will be perfectly legal. A resale by the seller, where a right to resale is expressly reserved in a contract of sale. A resale by seller where right to resale is expressly reserved. When you have expressly in writing reserved your right to resale. Sometimes it is expressly agreed between the seller and buyer that in case the buyer makes default in payment of the price, the seller will resell the goods to some other person. In such cases, the seller is said to have reserved the right to resell, and he may resell the goods on buyers to default. That means in such case, notice is not required, and he can keep the surplus or he can claim the losses. It may be noted that in such cases, the seller is not required to give notice of resale. He is entitled to recover the damages from the original buyer, even if no notice of resale is given. Where the property in goods has not passed to the buyer, the unpaid seller has, in addition to his remedies, a right of withholding delivery of the goods. The right is similar to lien and is called a quasi lien. It's called a quasi lien. Quasi lien, quasi, like we discussed, quasi means just like we discussed quasi contract. So quasi lien means just like a lien, not a lien, but just like a lien, tantamount to lien. Now, rights of unpaid seller against the buyer. What are the rights of unpaid seller against the buyer? Now, till now we had discussed right of unpaid seller qua the property, qua the goods. What right he has over the goods if he is unpaid seller. Now, let us discuss what rights he has if against the buyer. Okay, rights of unpaid seller against the buyer. Any unpaid seller can enforce certain rights against the goods as well as against the buyer personally. A right of unpaid seller against the buyer are otherwise known as seller's remedies for breach of contract of sale. The right of seller against the buyer personally are called right in personam, personal rights, right in personam. That means available only against the buyer. And are in addition to his right to against the goods. So he has two kinds of rights. He has right against goods, which we have discussed. He has right against buyer, and both rights go hand in hand. Both could be exercised simultaneously. Suit for the price. Now, what is the first right? He can file a suit for the price. Section 55, it says, where under contract of sale the property in goods has passed to the buyer, and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may sue him for the price of goods. If buyer is refusing to pay, seller will file a case in the court to claim the price. Okay, where under a contract of sale the price is payable on a day certain irrespective of delivery. If the date is fixed that you will make the price on that date, and the buyer wrongfully neglects or refuses to pay such price, the seller may sue him for the price, although the property in goods has not passed and goods have not been appropriated by the contract. Even though the goods are lying with the seller, but there was a date stipulated that on this date you will make the payment, but buyer refuses to make the payment, he can still file a case. Okay, if the property has been delivered or even if the property has not been delivered, but the key thing is he can file the case only when buyer wrongfully neglects or refuses. When buyer wrongfully neglects or refuses, but if buyer has a genuine ground which prohibited him from making a payment, like a curfew was imposed, like a ban was put upon the by the government, or like a demonetization kind of thing was there, or a COVID pandemic came up, in these situations he cannot file a case, because we cannot assume that buyer has wrongfully neglected or refused. Okay, situations will have to be taken care of. Suit for damages for non-acceptance, where the buyer wrongfully neglects or refuses to accept and pay the goods. The seller has made the delivery, but the buyer refuses to accept the delivery and even to make the payment. The seller may sue for the damages for non-acceptance. Okay, that is only a kind of a breach of contract. He may file for the damages. Repudiation of the contract before due date, like we discussed. Anticipated breach of the contract, okay, where the buyer repudiates means breaks, commits a breach. Where the buyer repudiates the contract before the date of delivery, the seller may treat the contract as rescinded and sue damages for breach. This is known as the rule of anticipated breach of contract, like we discussed. In advance, he has a notice that he is not going to pay, so he can initiate a suit. Suit for interest, section 61, where there is a specific agreement between the seller and the buyer as to the interest on price of the goods from date on which the payment becomes due. Now suppose the payment is to become due on 1st of the January, and there is a contract between the buyer and seller and understanding that if he does not pay, he shall pay an interest of 10%. Then he can claim that 10% interest from him. Okay, the seller may recover interest from the buyer. If, however, there is no specific agreement to this effect, the seller may charge interest on the price when it becomes due from such day as he may notify to the buyer. Okay, if there is a date set, then he can take interest from that date. If there is no such date set, then he can give the notice for seeking payment, and from that date he can collect the interest. In the absence of a contract to the contrary, the court may award interest to the seller in a suit by him at such rate as it thinks fit on the amount of the price from the date of tender of the goods or from the date on which price was payable. Okay. And even if there is no such contract, the court can still award him interest as per the court's own judgment. Rights of the buyer. Now, we have discussed rights of the seller and rights of unpaid seller. Now the act gives, because we are discussing sale of goods act, now sale takes place between two parties, one is a seller, other is a buyer, so there must be some rights to the buyer as well. What are the rights of buyer? Let us see. Buyer has a damage for the right to seek damage for the non-delivery, suit for specific performance, suit for breach of warranty, suit for anticipated breach, and suit for interest. Let's read them briefly. We have already discussed them in detail when we were discussing seller's part, so it will be a kind of a cakewalk for us to understand it in the buyer's perspective. Damages for non-delivery, where the seller wrongfully neglects or refuses to deliver the goods to buyer. Where now seller refuses to deliver the goods, then he can definitely file damages for non-delivery. Buyer. A shoe manufacturer agreed to sell 100 pair of shoes to B at rate of 1050 per pair. A knew that B wanted the shoes for the purpose of further reselling them to C at rate of 1100 per pair. On due date of delivery, A failed to deliver the shoes to B. In consequence, B could not perform his contract with C for the supply of 100 pair of shoes. In this case, B can recover damages from A at rate of 1100 rupees, 50 rupees per pair, which is the difference between contract price. Okay, because B could not fulfill his contract with the C due to default of A, so now he can recover the difference. Suit for specific performance. Okay, now what is a suit for specific performance? We have discussed. When you specific performance means you perform the contract in the specific manner. Okay, if there is a contract that you have to do this act in such way, then if you are not following your pattern as per in the contract, you can go to the court and take a decree. Court will direct the person or the other party or the party who is at default to perform the contract. Okay, to perform the contract, that is called suit for specific performance. That is a section 58, where the seller commits the breach of contract of sale. The buyer can appeal to the court for specific performance. The court can order for specific performance only when the goods are ascertained or specific. Okay, he can go to the court and seek specific performance. Now, court can order specific performance only when goods are ascertained or specific. When goods are identified, okay, when goods are identified, otherwise not. If the goods are unascertained, court cannot do anything, okay, because unascertained goods, it will be very difficult. A agreed to sell a rare painting of Mughal period to B, but on due date of delivery, A refused to sell the same. In this case, B may file a suit against A for obtaining an order from the court to compel A to perform the contract. That is, deliver the painting to A at the agreed price. Now, if he refuses to deliver the painting, court can direct him to deliver the painting and take the payment. Okay, this is the suit of specific performance. Suit for breach of warranty, section 59. Where there is a breach of warranty on the part of seller, or where the buyer elects to treat breach of condition as breach of warranty, the buyer is not entitled to reject the goods only on the basis of breach of warranty. But he may. Now we discussed that there are two things: warranty and condition. Okay, when the condition is breached, he can return the goods, but he can also treat the breach of condition as a breach of warranty. But when there is a breach of warranty, he cannot return the goods. What he can do is he can file a claim for the price or sue for the damages. Okay, he can either file a claim for the price for that warranty, or he can sue for damages for breach of warranty. Okay, so in these cases, this is the right of the buyer. This buyer can do. Repudiation of contract before due date. Okay, where either party to a contract of sale repudiates the contract before the date of delivery, the other may either treat the contract as subsisting and wait till the date of delivery, or he may treat the contract as resigned and sue for damages. Now, seller says before the date of delivery that I will not deliver. Now, buyer has two options. He can wait till the actual date of delivery as agreed in the contract, and if no delivery is made, then he can file a suit for damages, or he can then and there as well file a suit for damages that this person has refused before the due date. So he can file a suit for damages as well as suit for specific performance. Suit for interest. Nothing in this act shall affect the right of seller or the buyer to recover interest or special damages. Now we have discussed in the law of contract what these special damages are, so I do not need to again stress on these special damages. Ultimately, what is the issue is that nothing in this act prevents buyer or seller. This right is coextensive to buyer as well as seller. Both can claim interest from each other as well as special damages. In the absence of a contract or contrary, the court may award interest at such rate. That means if there is no contract, okay, then court may award interest to the buyer as per its own judgment and wisdom. In case of a sale of cigarettes which turned out to be mild weed and unfit for consumption, damages were awarded on the basis of difference between the contract price and price released. In the case of absence of transfer of title or registration, the purchaser cannot claim damages for breach of conditions and warranties relating to sale. Okay. When the transfer of the document has not taken place, when the title has not documentation has not taken place in favor of buyer, buyer cannot claim warranty or guarantee. Why? Because buyer has not now become owner. Okay, till the time he cannot become till the time he does not become owner, he cannot claim breach of warranty or guarantee or condition. Now we are on the last leg. Let us discuss what is auction sale. Okay, this may be sometimes asked. What is an auction sale? You must have seen in the picture in which a person is standing on a table and he is having a gravel or a wooden hammer in his hand and he is beating it on the table. 1,000 rupees 1, 1,000 rupees 2, and 1,000 rupees 3. At the fall of hammer, when he says 1,000 rupees 3, the contract is concluded. Now the contract cannot be taken back. Only option with the auctioneer is he can withhold the contract only before fall of hammer for the third time. Okay. An auction sale is a mode of selling property by inviting bids publicly, and the property is sold to the highest bidder. An auctioneer is an agent governed by the law of agency. When he sells, he is only the agent of the seller. Auctioneer is never the owner. Usually, he may be the owner as well sometimes, but usually, he is an agent only. He is acting on behalf of someone else. He may, however, sell his own property as the principal and need not disclose the fact that he is so selling. Okay, he is usually the agent, but he may also sell his own property, but he is not required to disclose that he is selling his own property in the auction. Rule of auction sale. What are the rules of auction sale? Where goods are sold in lots. When goods are sold in lots, like 20 table or 30 chairs, okay. Where goods are put up for sale in the lot, each lot is prima facie deemed to be subject of separate contract of sale, okay. When goods are sold in lots. So each lot, like there are four lots, so each lot is a separate contract. Each lot is a separate contract. That means four people can win four lots. Okay, it is not that that someone who's buying one lot will have to buy other lots as well. Okay, there are four or five lots, he can buy one, two, or three lots and not remainder. It is not that when he's buying one lot he'll have to buy all lots. Okay, each lot is a separate contract. Completion of the contract of sale. The sale is complete when the auctioneer announces its completion by fall of hammer or in any customary manner, and until such announcement is made, any bidder may retract from bid. Usually, the customary manner is fall of hammer, and before the fall of hammer, any party, either the auctioneer or the bidder, may retract or take back his promise. Right to bid may be reserved. Now, it may also reserve the right to bid. Right to bid may be reserved expressly or by on behalf of the seller, where such right is expressly reserved but not otherwise. The seller or any one person on his behalf may bid at auction. Okay. So the right to bid may be reserved, that only seller shall not himself make a bid. Okay, sometimes what happens that seller puts an auction his own painting. Suppose a painter puts his painting for auction. Now he does not tell other people. People are bidding, and he is now, when everyone is bidding, he is placing a higher bid so as to take the price higher. Because when someone says I'll buy it for 1,000 rupees, and the seller comes and he says I will buy it for 1,200 rupees, so the buyer will have to make bid which is higher than 1,200. So usually this is not allowed. Okay, so these bids expressly state that seller is not allowed to bid for his own goods, but sometimes if this is not expressly stated, then the seller can also bid for his own goods. Where the sale is not notified by the seller. Where the sale is not notified to be subject to a right to bid on behalf of the seller, it shall not be lawful for the seller to bid himself, or to employ any person to bid at such sale. For the auctioneer knowingly to take any bid from the seller or any such person, and any sale contravening this rule may be treated as fraudulent by the buyer. Okay, if seller is going to take part, he should inform people that I am also going to take part in the auction sale, and I will bid, or my agent will bid for my own property. If he does not inform people, that will be a fraudulent practice. Reserved price. The sale may be notified to subject to a reserved or upset price. Okay, auction sale may say that minimum price for the bid will be 1,000 rupees, or the maximum price can be 1 lakh rupees. It can be, these conditions could be imposed. Nobody can say that I will buy it less than 1,000 rupees. Why have you reserved the price? This is up to the seller. At what cost will he decide to sell his price? Nobody can decide it. Pretended bidding. If the seller makes use of pretending bidding to raise the price, the sale is voidable at the option of the buyer. Pretending bidding means seller puts his own agents in the bidders, and they are now bidding higher and higher so as to take the price higher, so that later on when some innocent buyer buys it, he'll have to pay a higher price, because the agents of the seller have already made the bids. So if this kind of bid is happening, then the contract is voidable and the buyer is not liable to buy it at that price. P sold a car by auction. It was knocked down to Q, who was only allowed to take it away on giving a check for the price and signing an agreement that ownership should not pass until the check was cleared. In the meantime, till the check was cleared, Q sold the car to R. It was held that the property was passed on the fall of hammer and therefore R had a good title to the car. Both sale and sub-sale are valid in favor of Q and R respectively. Okay, because he sold it. Okay, he knocked down. At the knock of hammer, the sale was complete. Okay, it was a subsequent agreement that only sale will be agreeable, will be valid only after passing of the check, clearing of the check. Okay, this was a subsequent condition, but the sale was complete at this point only. However, this is a disputed position. Different laws, some law says that sale was not valid, some say sale is valid. So in the books it says that such sale is valid, so we'll deem it valid. Inclusion of increased or decreased taxes in contract of sale, where after a contract has been made but before it has been performed, tax revision takes place. Suppose now GST is increased. Okay, now GST on the sale of shoes suppose is 12%, but before I deliver the goods to you, the GST is increased to 28%. Then where tax is being imposed, increased, decreased, or remitted in respect of any goods without any stipulation to the payment of tax, the parties would become entitled to read just the price of goods accordingly. Following taxes are applied on sale or purchase of goods: any duty or custom or excise goods, any tax or sale or purchase of goods. That means if there is no contract, it is not mentioned in the contract, then whatever is the latest price will be the price of the goods. If the taxes are increased, the buyer will have to pay the taxes. If the taxes are decreased, the buyer will get the refund. The buyer would have to pay the increased prices where the tax increase and may derive the benefit of reduction if taxes are curtailed. The seller may add the increased taxes in the price. The effect of provision can, however, be excluded by an agreement to the contrary. It is open to the parties to stipulate anything regarding taxation. This is a general position. If there is no contract, then this is the general position. But if there is a contract which says that taxes shall be this much, then there won't be any effect whether the taxes go up or down. The price is frozen already in advance. Okay, so now with this we are finished with our sale of goods act. I hope you had a nice understanding of the act.